And welcome, John. And we're happy to listen to what you want to tell us.
Um, Thank you very much. Can you hear me?
Yes.
Yes.
Great. My name is John Echevarria. Along with my wife, I own the Dodge Farm on the Tunbridge-Stratford border, which has two legal trails running across it. We're also the plaintiffs in the suit against the town of Tunbridge, seeking a declaratory judgment on who holds the authority to decide whether and how to maintain legal trails, the lawsuit you've heard a great deal about. I just want to say I appreciate all the time and effort you're putting into this. I frankly had thought that you'd reached the limit of your interest in receiving testimony and went off on a long delayed vacation to go bicycling of all things. But I'm happy to step aside from that and to participate in this conversation. It's my position that the Senate version of 488, the trails language in that bill, would expropriate the property rights belonging to my wife and myself and the property rights of hundreds of other Vermonters who hold land subject to legal trails in violation of the Vermont and US constitutions. And the reason it would do that is because this legislation would create an expanded trail easement. It would create a new scope, a broadened scope for the easement without the constitutionally mandated requirement of a necessity for the taking and without the required payment of just compensation. And this is a constitutional legal argument based on specific provisions of the US and Vermont Constitution, the Takings Clause of the Fifth Amendment to the US Constitution, and Chapter 1, Article 2 of the Vermont Constitution, which says, to paraphrase, that the government can take private property from citizens only upon a showing of necessity and then only upon payment of just compensation. Now, just parenthetically, Vermont has a particularly strong tradition of providing constitutional protection for private property rights, as you're probably most of you are likely familiar with. Chapter 1, Article 1 says that all persons have certain natural, inherent, inalienable rights. One of those is the right to acquire, possess, protect property. Then you go to the very second article in the Vermont Constitution, which is the Vermont Takings Clause. So in terms of, I'm not saying that the property rights provisions of the Constitution in Vermont are more important than other provisions, but they do have a priority of placement. The Takings Clause in the Vermont Constitution goes back to 1777 when Vermont adopted the Constitution for the Republic of Vermont. That was the first takings clause in America. It served as the model for the federal takings clause and the takings clauses that are in most of the other states around the country. And the reason it was included in the Vermont Constitution of 1777, as you know from your history, is because Vermont had a terrible battle between the settlers who received their grants from Governor Wentworth in New Hampshire and the New York colonial authorities who tried to steal Vermonters' land from them. So more than any other state in the nation, Vermont was born in a property rights battle, if you will. Now, of course, the legislature sometimes missteps and violates the Constitution, right? And there is a remedy for a taking. If the legislature does something that's a taking, people can sue, right? But that's plan B or C, I think, I hope. I mean, the government sometimes, the legislature sometimes does something that may infringe on the freedom of religion or freedom of speech. And of course, there's always a remedy. People can sue the government. But I don't think that generally speaking, we want to excuse constitutional violations by saying, oh, well, people can sue us if we did something wrong. The goal, I think, is to avoid the constitutional violation at all. And in order to avoid the constitutional violation at all with respect to private property rights, I respectfully suggest that the legislature should not go forward with the Senate language. This is particularly true because there's an alternative. The alternative is to do nothing this year, to wait, as this committee did in the prior session, and wait for a resolution of the ongoing lawsuit against the town of Tunbridge. I think, based on my personal professional opinion, that I'm going to win that lawsuit because I think we have the much better argument. But I'm not going to stand here and guarantee an outcome. I'm not going to disrespect the court by promising how it'll be resolved. The town could win. If the town wins, then this whole discussion goes away. Then the town has the authority to maintain the trails, and this takings debate goes away, and we can all go on about our business. On the other hand, if, as I expect, we prevail in the lawsuit, then we will all know what the law of Vermont has been, and the legislature can then confidently proceed in a constitutionally proper manner to figure out what to do about it. And there are a variety of things the legislature can do. One of the options, and it's not my favorite option, but one of the options is it could decide to establish a process for taking some or all of the 500 miles of legal trails, the maintenance rights with respect to the 500 miles of legal trails through a constitutionally appropriate eminent domain proceeding. In other words, towns and the state acquire rights of way and expand rights of way all the time through eminent domain proceedings. A process could be established to do that here as well. Before I go further, I just want to make a couple of points by way of background. How much time do I have? I started at what time?
I think you started at around 5, or no, we started before. It was like quarter to.
No, it was about more,
Five.
like 5 minutes.
Well, 5 minutes before 10, yeah. So,
Okay, so I'm
yeah.
planning on going for a little less than half an hour, and then I really want to answer your questions.
Sure, that's
I
fine.
just wanted to explain the background to this dispute, which is for 10 years, my wife and I live in Stratford. 10 years ago, we bought the Dodge farm, which is on the Stratford-Tunbridge border. And basically, the Dodge family, which had lived there through 2 generations for a total of 90 years, died out. Libby Dodge died in the house at the age of 100. And everyone in the area in Stratford and Tunbridge was very concerned about the future of this property, which was a iconic traditional hilltop farm that had been widely used for public recreation, that had remained in agriculture, and people wanted to see it preserved. After looking around for other people who wanted to buy it and not finding any, my wife and I decided to purchase it. And we did it with the goal of, we wanted to use it and enjoy it ourselves. We wanted to preserve public recreational opportunities. We wanted to restore and preserve the historic farmstead, and we wanted to maintain the traditional forestry and agriculture on the property. One of the very first calls we made when we bought the property was the Upper Valley Land Trust to arrange a donation of a very strict conservation easement protecting 99% of the property. Our second call was to the local snow machine club saying, you're good to go to continue to use the mile of snow machine trail across our property that goes through 4 or 5 different fields and through the woods on our property. Today, the property is open for snow machining, for hunting, for horseback riding, for hiking, for skiing, for a variety of recreational uses, not for wheeled vehicle use. We have the issue that we have run into has to do with 2 legal trails that are on the property. One of them runs from the farmhouse down the center of the traditional cow pasture. A small portion of that trail at the foot of the property has traditionally been used with our permission by the snow machine club and maintained by them with our permission. But most of the trail has been unmaintained. We have not maintained it. The Dodge family did not maintain it. I don't think it was ever maintained in the entire history of the existence of the trail. And it was important that it was not maintained because it was in the middle of a cow pasture, and it really is just the recreational trail through the middle of a cow pasture is just a conflict that cannot be managed. The other trail was, when we arrived, was designated in the town plan for walking use. It had apparently been maintained. We've continued to maintain it. And then the town, with the encouragement of bicycle advocates, say we'd like to open up these trails. We want to expand them. We want to use them for bicycle use. And we stopped maintaining the second trail. And in the course of this discussion, a dispute arose about, well, what about who has the right to maintain the trail? And the town said, well, we certainly have the right to maintain it. And I said, I'm a lawyer. I read this statute. You don't have the right to maintain it. And we disagreed on that. We brought a suit to try to resolve that legal question. And it's taken forever to get to this point where we finally gotten our case fully briefed on the merits in front of the Superior Court, and we're waiting for a resolution of that issue any minute. The other thing I just want to say has to do with my background, which is I've been a member of the bar for 45 years. I'm a professor at the Vermont Law School. I've taught the first-year property course. My particular specialty is constitutional property rights. I've litigated property rights cases throughout the state court systems and the federal court system, including in the U.S. Supreme Court. I've written innumerable articles and books, and I've received awards from the American Planning Association, the American Bar Association, and the U.S. Department of Justice for my takings work. Now, not everybody agrees with me. My ideas about how takings doctrine ought to be improved, but the basic doctrine, I got down cold. You know, I'm an authority on this stuff. So I can speak with, feel free to disagree with me, but I feel confident in the positions I'm advocating in court and the ones I'm presenting to you here today. Excuse me, let me just catch up with myself. So the question is, why is this a taking? And there's sort of two parts to this. One is if, and this is just if it's true that my wife and I and other landowners hold the authority to maintain and repair the legal trails, and this legislation that the Senate version is enacted, that would be a taking. Because it would be a physical occupation of the property for an additional purpose by the government. I don't think that's a debatable issue. I don't really want to go on, waste your time talking about it. Damian Leonard is in full agreement with my position. I know that my former student, Kyle, who works for the League of Cities, submitted some written testimony that takes a different view. I'll just say that it was a very superficial analysis and it's incorrect. And I'm not going to say more about that. The issue is, well, is it true that the landowners have this statute, the right under the statute to maintain the trails, or does this belong to the towns? And the argument goes as follows. If you pick up the Title 19 and you look at 301 to 310, which deals with town rights of way, you see a whole slew of provisions that recognize, that grant, that authorize towns or require towns to maintain class 1, 2, and 3 roads, and give them at least discretionary authority to maintain class 4 roads, but not a whisper of a suggestion that they have authority to maintain legal trails. So in section 301, the highways are defined as class 1, 2, or 3, or 4 highways, which the town has the authority to exclusively or cooperatively maintain. Then the next definition is trails. And the definition of trails says they're all either old class 4 roads or they're newly created trails. There's not a whisper of any reference to maintenance or repair. You go to section 304, which is the list of 25 things that towns are authorized to do with respect to rights of way. There are about half a dozen provisions in there referencing, describing, authorizing town authority to maintain highways. Not a word, not a whisper of a suggestion that towns have authority to maintain trails. And then you get to 310, which 310A says towns must maintain class 1, 2, and 3 roads. And then 310B says they may maintain class 4 roads. And then there is a provision that says towns have no responsibility for doing maintaining legal trails. Again, no indication of an intention to grant authority. In dealing with similar statutes where the legislature says, in this situation, this authority exists, but in this closely related circumstance, the legislature does not confer authority. The natural way of reading the statute, the way the Supreme Court reads these statutes, to say, well, obviously the legislature intended not to confer that authority. Secondly, the kicker in this argument is you read the statute as it evolved over time. Because from 1973 to 1986, the legislature explicitly conferred authority on the towns to maintain legal trails. Very clear, very explicit. And then in 1986, the legislature amended the statute and eliminated that authority. So it's no accident that the statute today doesn't contain any reference to any reference to trail maintenance authority, because the legislature took it away in 1986. And then the third point I want to make is that the reason the legislature took it away, and you might say, well, why would they take it away? I mean, it's maybe the towns don't want to use the authority, but why not leave it to them? Why not give them the option of using the authority? The judgment of the legislature in 1986 was that it was better to eliminate the town authority, because then they could never be sued for abusing the authority. They could never be subjected to costly litigation. They could never be forced to do expensive things as a result of litigation. Before 1973, towns had a whole collection of roads. They were all undifferentiated. There were no legal distinctions between them. Towns had a legal obligation to maintain all their roads. The state provided some financial aid to the towns to maintain the roads, and the amount of state aid depended on the mileage of roads. And it was a well-known fact that towns maintained lists of roads that were as long as they possibly could, because that increased the amount of state aid they got, even though a great many of the roads they had on their roads list were not in fact being maintained. That worked fine until the 60s and 70s, when the population of Vermont exploded and people bought up properties up old roads, and they went to the select board and they said, I'm here. My family and I are here. We'd like to be able to access our property, and we need to make sure the school bus can get up our roads so our kids can go to school. And this explosion of population and a demand that roads be maintained created a financial crisis. Senator John O'Brien, in a memorable remark, said that the towns in Vermont are going to go broke under current law, trying to keep up with their obligation to maintain roads. The result of that in 1973 was the modern highway classification system. And the legislature said, towns we're going to divide the roads into 1, 2, 3, and 4. Towns are going to be obligated to maintain class 1, 2, and 3. We're going to provide financial support targeting highways 1, 2, and 3. With respect to class 4 roads, the towns are on their own. We're not providing any more state support for that, but we're going to tell the towns they don't have to maintain those roads. They can do it or not. That was an important change. It became discretionary. And at the same time, in 73, the court said, for this purpose, trails are the same things as class 4 roads. So the towns had discretionary authority to maintain class 4 roads or trails. And then, as you've heard from Damien, in 1986, the legislature recodified Title 19. And they initially said, well, we're just going to rearrange the language and clean things up. We're not going to change anything. But then when they got into it, they started changing things. And one of the things that they did was to take trails out of the highway system entirely. Trails are no longer highways. They're trails. And the authority that used to apply to discretionary authority, that used to apply to roads and used to apply to class 4 roads and to trails, now applied only to class 4 roads, and the towns had no authority with respect to trails. And what the legislative history suggests is that and this is based on a colloquy in a hearing between state transportation officials and legislators, was, even though the towns had discretionary authority to do work on class 4 roads and legal trails, and that protected them from some liability. It was far from a perfect protection, because if they acted in an arbitrary or discriminatory way, somebody could sue them, and they could prevail. And then the remedy could be quite costly. So it turned out that just giving the towns the option of not doing anything really wasn't enough to protect them from liabilities. And so and that's the only explanation that I have seen after days of poring over the archives for what the legislature did in 1986, was to say, we're just going to take away the authority of the towns to do this. That way they can't be sued. You know, saving towns money was priority number one, and there didn't seem to be any other priorities at issue there. And what the legislature apparently had in mind was, these are going to be forest paths used for walking. The landowners will maintain them. The landowners will maintain them in cooperation with the neighbors. It's just something that we're going to provide that the towns are going to wash their hands of this responsibility in order to protect towns from financial liabilities. And so that's how we got to this. That's how the legislature got to the decision it made in 1986 and the position we're in now. It may not. You know, given all the interest in recreation and biking today, it might seem a little odd, but that was not part of the equation back in 1986. I know I've gone on at some length, but I'll just say that the proposed legislation would radically change what the legislature did in 1986. Now, you've heard, and I've heard, statements that this is just a clarification. Well, it's not a clarification. That's just nonsense. All of the provisions of the current law that support the conclusion that there is no authority to maintain legal trails would be modified in a very substantial and significant way by the proposed legislation in order to give towns an authority that they do not have. And in the process would take the private property rights of the landowners. Let me just, if I may, make two final points. One is that the state of Vermont, and with all due respect, the legislature, and certainly myself, know precious little about the legal trails in Vermont. The Vermont League of Cities did a survey of towns, of all towns with legal trails. 3/4 of the towns did not respond to the survey. The 27% that did respond gave mixed responses. Some said we've never maintained our trails. Some said we do maintain trails. In talking to people around the state, I've discovered that trails are very different from one place to another. There are some long, valuable trails. There are also trails that are redundant of other trails. There are trails that go onto private property and dead end there. The 500 miles of legal trails in Vermont were not a systematically created system. They were a hodgepodge of opportunistic decisions to change mostly class 4 roads into trails. A great many of the class 4 roads were thrown up entirely. And looking back at it in different towns, it's impossible to figure out why certain class 4 roads were thrown up and some were turned into legal trails. Many of these legal trails, because they were old class 4 roads, go very close to private homes, go through farm fields. They're in many instances in precisely the wrong place for where you would want a recreational trail. But some, I understand, are more valuable. But the only point I want to make is that there is not good comprehensive information about the values of these trails, the conflicts they create, and I think it would be a great service if you were to accept my recommendation that the legislature not move forward, that the Department of Forest, Parks, and Recreation be directed to gather more information about the legal trails. The final point I want to make is that there is no emergency. I know that interest groups and bicyclists who are writing you letters are urging prompt action to deal with this issue, but there is no emergency. The house is not burning down. the fact of the matter is that to some unknown degree, different towns are now pursuing different courses. Tunbridge has never maintained the legal trails in the town. They've been in existence for 40 years. They've never asserted the right to maintain the trails. They never actually maintained the trails. Just recently, at the urging of the bicycle advocates, they say, oh no, we want to start maintaining them. But a whole lot of towns have never maintained the trails. Some towns have asserted the right to maintain the trails, but in fact, landowners do the maintenance. And I think in some other towns actually do maintenance. But none of that is going to change this year. There is a pending lawsuit. It's been pending actually for 3 years. It hasn't been decided. Once it's decided by the Superior Court, it'll be binding on John and his wife Karen and the town of Tunbridge. It won't be binding on anybody else because it's just a Superior Court decision. So the town of Pomfret or the town of Randolph can say, well, that's interesting, but we have a different view of the law, and we're going to continue through 2025 doing exactly what we've been doing. So I know of one other instance in the state where a landowner has adopted our position and said to the town, we don't think you have the right to maintain the trail. And the town says, no, we think we do. And there's sort of a standoff, and I guess the trail's not being maintained. But I think in 99% of the situations around the state, trail use and trail maintenance that is happening or not happening is going to happen or not happen this year as it's happened or not happened in years past. And there's no need for the legislature to take precipitous action in order to address some serious emergency. So I will stop there, and I welcome your questions. Thank you very much.
Thank you. Are there any questions for Representative Burt?
Yes, regarding your statement about the intent of the legislature in 1986, do you have that they wanted to get rid of the trails? They were the maintenance of the trails for financial reasons. Do you have you've seen copies of committee meetings, or how do you know that that was part of the conversation?
So I went up to the state archives and pulled all the hearings from the 1986 recodification effort. And I can't remember if it was a House transportation hearing or a Senate transportation hearing. And there was a very interesting colloquy between state agency leaders, transportation agency leaders, and the legislators. And there was some discussion about the need to modify the definition of Class 4 roads and trails. And one of the legislators said, well, what do we care about trails and Class 4 roads? Because it's really not a burden on the towns, because the towns have complete discretion as to whether or not they're going to maintain the trails, right? So it doesn't cost them anything unless they wish it to cost them something, because they undertake some maintenance. But the response of the agency head, and I can't remember if it was the agency head or the general counsel of the agency, who said, well, yeah, that's fine until somebody sues you. And he didn't go on and on about what that was, but there were, when he was speaking, two kinds of lawsuits that were out there. One was these suits that Damien has alluded to, in which persons whose trails, whose Class 4 roads were not being maintained, objected that somebody else who was on a Class 4 road was getting maintenance. And they sued, sometimes successfully, claiming they were being discriminated against. And the court said, the towns have discretion whether or not to maintain the trails, but they can't do it in a discriminatory way. And if they do, then they can be subject to suit. And then we're either going to require that the town uses discretionary authority to maintain the trails, or require the town to upgrade it to Class 3 so it will necessarily be maintained. The other kind of lawsuit had to do with liability for interfering with water flow. In the middle of the 19th century, the Vermont Supreme Court said, notwithstanding the general immunity of localities from suits for their official judgments, if a town manages a road, including constructing culverts or constructing culverts in an improper way, with the result that person's property is damaged, then the town is liable. And that is the liability rule that gives rise to the responsibility of towns to take care of culverts on all the town highways. And I think that there was a concern about that as well. I think what the legislature was doing in 1986, and this is an inference from this legislative colloquy, is they didn't want towns to be required to put culverts on trails, and they didn't want towns to be subject to liability for decisions about whether or not to maintain legal trails. So they just said legal trails the towns have no authority. If towns have no authority, then they can't be sued, and we're going to save everybody a lot of money and trouble.
Any other questions, Representative White?
Yes, thank you. I just wanted some clarification on your particular situation, just to make sure I was understanding it correctly. So the Dodge Farm on the Stratford-Tunbridge line that you were referring to has a number of legal trails on that property. And the ones that okay, only two. But you also talked about you've got vast trails going through your property that the snowmobilers are using.
Yes.
So is that one of the two trails that you're disputing, or is that a different trail?
The vast trail runs for about, the vast trail runs for about 150 yards across our property on a legal trail. It actually didn't used to be on a legal trail. It used to run through the cow pasture. But when we put up fencing in order to comply with the Clean Water Act, we wanted to get the vast traffic out of the trail, out of the pasture and onto the trail. And so I got together with the vast people and we cleared the trail. And so now the vast trail runs about 150 yards along one of these trails. But the lion's share of the vast trail is on our private property.
Okay. Okay, and that vast trail used to be on that cow pasture trail, in the middle of the cow pasture, but then you moved it because of the Clean Water Act and the fence. Am I understanding that correctly?
Yes, right. Because because if we would have, there was a permanent fencing was being put up, and so it was in that particular field, it was no longer convenient to have the snow machines go across the field. It was better that they go along the trail on the edge of the field.
Okay.
But it was a decision that I worked out with VAST with no involvement whatsoever from the town. And we cleared the trail so we could use the trail for the VAST purposes without consulting the town, and nobody involved in this effort thought the town needed to be consulted, because nobody thought the town had a responsibility for deciding whether and how to maintain the legal trail that VAST was going to use after this project.
Okay. And so the one trail in dispute is the one in the middle of the cow pasture, and the other trail in dispute, could you just remind me of the description of that? I just want to make sure I understood that.
So that's that also starts in the they both sort of start in the building envelope that is left after the conservation easement was put on the property, and in the farmstead where the two barns are and the houses. Say the Baptist Hill Trail, which we've just been talking about, that goes down through the pasture and is unmaintained until you get to the small section of Vast Trail. The other trail, which goes at right angles to that, is the Orchard Trail, which was when we acquired the property, it was open, it was passable, and we assumed the responsibility to maintain it. Nobody else was maintaining it. No, as I say, the town never asserted authority to maintain the trail, did not maintain the trail. And so we maintained the trail. And that that goes on, that continues on to a neighbor's property. When this dispute arose with the town about whether or not who had the authority to maintain the trails, and an interest in the town in changing the rule, the policy that was in effect when we bought the property, which was walking only on the Orchard Trail, and threatened to put bicycles on that trail. We said, well, we're going to exercise our authority not to maintain that trail.
Okay. And again, so the trail in the middle of the cow pasture was being used by Vass prior to your purchasing the land. And then at some point you and Vass decided to move that trail. And Vass continues to maintain that trail for wintertime snowmobile use. Is that right?
Yeah, when originally the vast trail crossed the legal trail, but didn't use it because it went entirely through private fields. Then some years after we bought the property, we cooperatively with Vast moved the Vast trail so it was in the path of the legal trail for about 200 yards. So we could get the Vast traffic out of the cow pasture.
Thank you.
Any other questions? If not, thank you very much for joining us today, John. Appreciate it.
Okay, I'm happy to answer any follow-up questions that people have, any. And I'm happy to provide the hearing record from the in 1986 legislative deliberations, if that would help you understand how the legislature came to the determination it made in 1986 to eliminate this authority.
All right, if we seek that, we'll reach out to you. Thank you very much.
Thank you.
I think now, we have a little break until 11 where Secretary Joe Flynn is coming in along with the Commissioner of Public Safety, Jennifer Morrison, and they're gonna give us an update on the camera situations in the work zones. Hopefully, I'm not sure what they're gonna tell us, if there's an agreement or not, but we'll get an update on that, but see, now we're half an hour